All right, my name is Ron Chapman. I am a shareholder at the employment law firm of Ogletree, Deakins, and with me is Paul Nason, who's a partner at Locke, also an employment lawyer. So Paul and I have done this presentation together for, I don't know how many years now, it's 12, 13, 15? 15. It just feels like 50. So this is affectionately known as the Lawyer Hour at the North Dallas Chamber of Commerce's HR conference, which is the highlight of any conference, don't you think, the Lawyer Hour? So what's going to happen here is I'm going to give you roughly a 10-minute overview of the latest and greatest developments in the world of employment law. And then Paul and I are going to talk about some various scenarios that you're going to see. And we have a little video special to help us out with that hopefully you will enjoy. And hopefully we're going to have slides. We're good? All right. So one of the favorite things about my job is that I get calls from clients, whether that's HR people or an in-house lawyer or even a business owner, and they will tell me some scenario that they're dealing with and ask me for my advice on how to either get them out of trouble or keep them out of trouble. I always tell them it's cheaper and easier to keep you out of trouble than it is to get you out of trouble. So call me before you get in trouble, and that helps. But as a result of what I do for a living, I get to hear a lot of really good stuff about what's going on out there. Unfortunately, most of it I can't really talk about because it's confidential, and we have these silly ethical rules for lawyers that mean I can't talk about it. But sometimes, if it's generic enough, I can relay a story to you, and I just can't reveal the company. So I want to share a story with you. So yesterday, I got a call from a general counsel of a prominent employer, and he says, Ron, I've got this scenario I want to run by you. I want to get your advice. He says, we have a CEO here who's one of those alpha dog types who likes to bark people around and get his way no matter what he does. And we had a hotline complaint a little while ago about his behavior. How many people have a hotline, an ethics hotline, something like that, where people can anonymously report tips? Yeah, so the same deal. So they get this hotline complaint about the CEO. That's kind of a big deal. So the chief human resources officer of this company is tapped to conduct an investigation into the propriety or lack thereof of the CEO's behavior. So the CHRO, the chief human resources officer, starts this investigation and realizes that it's kind of a big deal. They're interviewing witnesses, they're looking at documents, they're trying to get to the bottom of what happened. And the chief human resources officer is frustrated because she's not getting all the information she needs. So she asks for more resources and cooperation to help her with the investigation. And the CEO says, this is in a meeting, in a board meeting or something, says this investigation is stupid. I don't even know why you're looking into this. We ought to just drop this whole thing. And the general counsel who's telling me this story says, well, I explained to my CEO, this is kind of important. We have this complaint. We need to investigate it, so we need to support the CHRO and get her the resources she needs. So this is my call yesterday with the general counsel. He lays out that background and he says, and then this morning the CEO fired the chief human resources officer. And as if that weren't bad enough, as if that weren't bad enough, this is the GC talking. I said, I asked the CEO, why did you fire her? She was, in the middle of this investigation. As far as I can tell, she's doing a good job. And the CEO says, well, you remember 6 months ago when she messed that thing up? Well, that's why I fired her 6 months ago. Unfortunately, again, I can't reveal the employer involved here. I wish I could share who that is with you, but unfortunately I can't. But I hope that anecdote reinforces a couple things. When you're evaluating a potential termination, there are always two key questions to ask. Why are we firing this person? And why now are we firing this person? So keep that in mind, just as you deal with your own issues, unrelated to anything going on anywhere. Back to my presentation. I am frequently asked to predict what the impact of the Trump administration is going to be on employment law. And I kind of chuckle when I get that question because it's a little bit difficult to predict what someone's going to do when that certain someone himself doesn't know what he's going to do until about 2.7 seconds before he announces that decision. So it is very difficult to predict the future, and it reminds me of a Mark Twain quote about the difficulties of predicting the future, particularly when it involves the future. So keep that in mind as we go forward. So Paul and I are going to give you some predictions, but keep in mind we don't really know what we're talking about. We're just kind of throwing darts at a dartboard. But we're going to have a lot of fun along the way. So I can give you a little bit of update on what things that have actually happened. We have some leadership changes at the EEOC and the NLRB. So the big three agencies, federal agencies you need to worry about in the world of employment, labor and employment law, the EEOC, which everyone knows, the NLRB, the National Labor Relations Board, and the Department of Labor. So we have new leadership at all three. We have a new acting chair at the EEOC, a new acting chair at the NLRB. These two folks have been lifetime public servants. They are very experienced, very well respected, really no controversy there. There will be more appointments to come, and it remains to be seen what the impact of those will be down the road. But these two appointments, in my mind, were very non-controversial. As was this one. Secretary Acosta is now Secretary of Labor. Very tried and true, very well respected, very experienced person. Bipartisan support for his nomination. Expected to have a very, very balanced approach. What the impact from these agencies will be, it's going to take some time to shake out. These appointments come in, they have to get the lay of the land, implement their changes, and then through the regulatory process, those changes take months, if not years, to actually be implemented. So I don't see any really fast changes coming from those folks. The one I do is our new justice on the Supreme Court, Neil Gorsuch, who's sitting on the court now. He's been confirmed. The impact from this Supreme Court pick is going to be much faster than the picks for the various agencies. Who is Neil Gorsuch? He grew up as a corporate lawyer, representing corporations. He's been on the 10th Circuit Court of Appeals previously for some time, where his opinions were pretty middle of the road, definitely on the pro-employer side of things, but not in an outlandish way. Very well respected, very fair judge. We expect him to follow in the footsteps of his predecessor on the court, Justice Scalia. I don't think Justice Gorsuch's appointment to the Supreme Court really affects anything at the Supreme Court because of who he is replacing. Justice Scalia was very conservative. Justice Gorsuch will be conservative as well, so I don't think that really changes anything. The next pick, that could really change things. We'll see what the future of the Supreme Court holds. So the big news of the last year in the employment law arena was under the Fair Labor Standards Act, and as I think everyone in the room knows, there was a proposal out of the DOL to change the requirements for people to be exempt from overtime, basically raising the salary threshold, almost doubling it to $48,000. That was set to go in effect on December 1, 2016. Companies across the country were planning for that. What are they going to do? Are they going to reclassify people from exempt to non-exempt? Are we going to raise salaries? Or are we going to limit them to under 40 hours? How are we going to get around this new rule? And then boom, November 22, the whole thing was enjoined by a judge in Sherman, Texas. Slapped a nationwide ban on the DOL's proposed rule. And Paul and I are going to talk more about where that's going to lead and what the possible outcomes of it are. But where does it stand right now? The appeal is still pending. It was interesting that as soon as that injunction came down, the Department of Labor requested this expedited appeal, that we need an answer from the Court of Appeals immediately. We can't wait. We've got to go forward. And then the new leadership of the Department of Labor comes in and they request briefing delay. Now they're trying to slow it down because they're trying to figure out what their position is. So we don't really know where this is heading. I've got a few ideas that we'll talk about in a minute, but the briefs at the Court of Appeals are due in June, and we'll know a lot more then. So here's a big issue that's brewing out there, and it's going to be a really big issue in the next 7 months or so. Your biggest risk as an employer in the employment law world is a class action lawsuit. There has been an absolute tidal wave of class action litigation, particularly over overtime pay, across the country, where the number of such cases has absolutely skyrocketed. Many companies have gone bankrupt as a result of the exposure they face in these lawsuits. So to help prevent those kinds of cases, a lot of employers have adopted an arbitration agreement with a class action waiver. It's basically a document, every employee signs it, says I will not bring a class action against my employer, I won't participate in a class action. Any dispute I have with my employer will go directly to arbitration, which is a private dispute resolution mechanism, and just between me and the employer, nobody else. So then there's this big battle over whether those class action waivers are valid and enforceable. The National Labor Relations Board took the position in January 2012 in a case called D.R. Horton that those class action waivers are invalid because they violate employees' rights to come forward and gripe about terms and conditions of employment as a class. The NLRB's position is that employees have that right to bring a class action, and therefore a class action waiver violates those rights. 4 different courts of appeals have now rejected that position and said that class action waivers are in fact valid, but 2 courts of appeals have said the NLRB is right, that such a class action waiver violates employees' rights. So the Supreme Court, thankfully, has taken up this issue. We are going to get a definitive ruling, once and for all, on whether class action waivers are valid and enforceable. That case will be heard by the Supreme Court in October or November, and then we will get a decision from the Supreme Court in roughly January. That's going to be a big, big issue, because regardless of how the court rules, every employer in America is going to want to consider, do I want an arbitration agreement with a class action waiver? And if so, do I need to change the wording of either the agreement I have or the agreement I'm contemplating based on the decision from the Supreme Court? So keep your eyes on that one as we go along. So what's very, very common for employers is when they terminate an employee or an employee's leaving, they may give them some severance pay and have that employee sign a severance agreement. A severance agreement will contain all sorts of bells and whistles, different provisions, different clauses, such as those listed on here. Several different agencies, including the EEOC, the SEC, the Securities and Exchange Commission, the NLRB, and others, are now attacking those provisions, saying that they violate certain rights of employees. So whether this continues under the Trump administration, we're going to have to monitor. But right now, those agencies are very, very actively scouring severance agreements, looking for provisions that they think violate the law. So the form you were using 5 years ago for a severance agreement, I promise you, has problems with it, and probably and needs to be updated. So the takeaway for you folks is, if you ever give severance agreements, make sure your form is updated with the latest nuances in the law. All right, trends. I'll give you some takeaways. These are just my observations of what's going on out there. First and foremost, litigation over background checks is skyrocketing. There's a wave of this coming, and Paul and I will talk more about it. But if you are a company that does background checks, you need to be paying attention to this and make sure you're doing it correctly. A lot of companies that think they're doing it right are not doing it right, and this is a very, very important issue for employers across the country. Another one, it's hard enough to comply with federal law, and then you throw in state-specific laws. How many folks here have employees in California? I pity you. So sorry. It's very, very difficult to comply with the plethora of state-specific laws that are out there. A practice that is compliant in Texas is not going to be compliant in California in every situation. A practice that's compliant in California may not be compliant in Oregon. It's very much state-specific. As if that weren't difficult enough, now some municipalities have passed their own ordinances, which makes compliance at a multi-state level even more difficult. San Francisco, Philadelphia, just to name 2, have their own state-specific or municipal-specific ordinances that you, as the employer, are charged to comply with. So that's very difficult as well. Managing leaves of absence is probably the number one question I get when people call me and ask me for advice. It's about a leave of absence situation. Very, very difficult. Lots of different statutes at play, from workers' comp to ADA to FMLA. How do we get this person back to work? Or if we really want to get rid of them, how do we get rid of them without getting a lawsuit? Not that anyone here would want to do that. Occasionally we get those questions. So managing leaves of absence is a major, major headache, and will continue to be. Debate over LGBT rights and whether sexual orientation is protected under Title VII, the federal statute. Lots of states and many municipalities, including Dallas, including Fort Worth, have passed ordinances protecting sexual orientation and prohibiting discrimination based on sexual orientation. But the fight at the federal level continues, and we'll continue to monitor that and see where it goes. Finally, the Trump administration, you might have read that immigration is sort of a big issue for President Trump. Might have heard something about that. What happens with the travel ban, I don't know. We'll have to wait and see how the courts shake that out. But what I do know is that enforcement on I-9 compliance is up. There are more ICE officers on the street, and they're doing more audits. They're doing, I don't like to use the word raid, but they're doing more audits. Compliance efforts are definitely up. So if you have any qualms about your I-9 compliance levels, I would encourage you to do a little cleanup, do maybe a little self-audit to make sure you're okay before the government comes on. What does all this mean for you, the HR professionals of the world? More headaches. I thought about job security, but I thought that might be a little too glib. So we'll just go with compliance headaches are definitely up as well. So with that, that concludes the overview portion of the Lawyer Hour. And now we're going to get into the real meat and potatoes part. But first, we have a little video to help sort of set the stage a little bit.
All right, everybody, shut it, zip it, sit down. Thank you. All right, good morning, everyone. I'm Sean Spicer. Do not call me Spicy, okay? I am Sean. This morning's press briefing, it's going to focus on the administration's labor and employment issues, okay? We're not going to talk about anything else, okay? I know some of you probably want to talk about North Korea, probably want to talk about Syria, okay? We're not talking about any of that. If you ask me a question that's not about labor and employment issues, you will be removed. Your credentials will be, revoked. R-E-V-O-K-E-D, okay, CNN? You got it? Write it down? Thank you. Now, I'd like to start with a short introductory statement, okay? I have prepared this. As you know, to date, President Trump has created thousands and thousands of terrific jobs. The economy has grown hugely. The president has created the most jobs in the first 100 days of any president in recent history, okay? And if you don't know that, that's because the lamestream media won't report it, okay? So please check your facts, or better yet, check the facts that I give you today, all right? Okay, now before I open the floor up for questions, I want to let you know that I have standing by two special advisors on labor and employment issues, Mr. Ron Chapman from Ogletree Deakins and Mr. Paul Nason from Locke. Okay, I will not need them, but in the case that I do, I will pass it over to them and they can help with your terrible questions, okay? Let's open this up. Anybody have any questions?
Sean.
Glenn, New York Times.
Thank you, Sean. I want to ask about the recently confirmed Secretary of Labor, Alexander Acosta. Many people are concerned, as you can imagine, that he may in fact roll back many of the pro-employee policies of the Obama administration. Do you care to comment on that and perhaps provide some insight into what it'll look like under the Trump administration? Do you care to comment on that?
No, Glenn, I don't, but I guess I'll answer it, okay? I can assure you that Secretary Acosta will not conduct business as usual, okay? He will do many great things, okay, just like everyone else in this administration. Now, the Department of Labor does many big things, okay? It does some things even bigger than that, okay? Now, I believe that Secretary Acosta will roll back several of these regulations, okay, that affect clean water and clean air that we know are disastrous for business. And I think I may have the wrong agency there, so I'm actually going to turn this one over to Ron and Paul. Thanks.
Hey, Paul, can you help Spicy out here? He may need some help.
Isn't that fantastic? That's fine. So to, that's so funny. Anyway, well, as Ron said in his talk, to forecast what an Acosta Department of Labor might do is a little bit hard. I think it's safe to say that as a general rule, the Acosta Department of Labor will be more pro-employer than the previous Department of Labor under Secretary Perez. But I think the change is going to come slowly. Several reasons for that. There are several top positions at the Department of Labor that are still unfilled. The head of Wage and Hour is still unfilled. The head of OSHA, the head of the Employee Benefits Security Agency is unfilled. So I think until those spots are filled, I think some of the developments are going to move slowly. Secondly, as you may have seen in the press, although it's one of his more, I think, less reported executive orders, President Trump issued an executive order directing his agencies that for any new rule they issue, they have to revoke 2 rules. It's called the 2-for-1 executive order. So how that might affect new rulemaking by the Department of Labor remains to be seen. And then thirdly, obviously, government moves slowly just in general. So for the time being, until some of these higher level positions are filled in, the policy is set and directed to the field workers, I think you're going to find some of the field workers are still just as aggressive as they were under the Obama administration. I will say that, as Ron mentioned, Secretary Acosta is very well regarded in Washington. He has a lengthy government service with the Department of Justice, the National Labor Relations Board. He was a U.S. attorney in the Southern District of Florida, so clearly very qualified. Being the son of Cuban immigrants, he has more progressive views than some in the administration. He's expressed pro-immigration, pro-diversity views in the past, so I think that may come into play. Now, on some of the specific topics, the first big issue, I think, is what's going to happen to the overtime rules. And what is the Department of Labor going to do? As Ron mentioned, the Department of Labor just asked for another extension on filing their final brief before the Fifth Circuit could rule on the case, and that extension is until June 30th. So we certainly won't know anything until June 30th. There are several scenarios that could play out. The Department of Labor could decide to withdraw the appeal. That's a possibility. The Department of Labor could decide to withdraw the rule in general. Another thing that is pending out there that makes it a little difficult is the AFL-CIO has asked to intervene in the case, and that's another motion that's pending in front of the district judge in Sherman, along with summary judgment motions. And what that means is if the AFL-CIO is allowed to intervene in the case, then it would be more difficult for the Department of Labor to potentially withdraw the appeal. So I think it's a wait and see what's going to happen with the rules. I think there is a possibility over the long term that the Department of Labor may look at issuing a new rule with a lower salary basis.
And predictions are tough in this area, but I agree with Paul. If I were forced to make a prediction, it would be this. I think the Department of Labor will withdraw the appeal, ultimately, thereby allowing the injunction to go into place, be permanent. But at the same time, I expect the DOL to announce that they're going to continue to study the rule, get more input, and ultimately come out with a new rule, which will increase the salary threshold, but not all the way to $48,000. I think it'll be in the low 30s probably. So I suspect a year from now, when we're up here doing the same thing, for those of you who come back, and that should be all of you, right? We'll be up here reminding you of this prediction and telling you how accurate it was.
Right, absolutely.
Unless that's not what happens, and then you won't hear anything about that prediction.
But we'll throw out the alternate fact.
Yeah, absolutely.
Our answers will go into effect and it won't go into effect.
Yeah, absolutely.
I think another interesting thing that came out of this litigation, and not to get bogged down in a legal issue, is that the district judge in Sherman actually raised the question as to whether the Department of Labor even had the authority to set a salary basis at all. And so the Department of Labor is going to have to be careful about how they handle this, because they certainly don't want their ability to do that to be called into question in any kind of final judgment. A couple of other issues outstanding at the Department of Labor is, will they do anything with the minimum wage? President Trump during the campaign both supported and opposed the $10 minimum wage, however you do that. But anyway, so look for any minimum wage increases probably to be left to the states. I mean, several states already have higher minimum wages than the federal minimum wage of $7.25. I think on issues of another big DOL issue, independent contractor and joint employment, I think the DOL is going to keep enforcing that, especially until some of the higher level positions are filled and some of the field directives come out, maybe telling people to stand down on those issues a little bit. But who won't stand down on independent contractor and joint employment are the states. The state revenue agencies are going to keep coming after employers hard, because that's where the money is. So even though the federal government might back off a little bit on independent contractor misclassification issues, make sure that you are classifying your people appropriately, because the states will still come after you. I think finally, as just a general prediction, I think the Acosta Department of Labor will focus more on compliance and employer compliance than it does on enforcement. That's been the history of Republican Department of Labor's, Republican administration Department of Labor's. And one interesting thing that may go back into effect is the DOL under Acosta will likely reinstate the ability of employers to seek opinion letters from the Department of Labor. That's something that went by the wayside under the Perez Department.
Just to piggyback on one thing Paul said, and then we'll get back to spicy. I know that's what you're all here for. The Texas Workforce Commission has become much more active in its own audits, and they're looking for revenue streams. So if you're using a large number of independent contractors, you're increasing your chances of getting audited on that, which isn't to say you can't do it, just make sure you're doing it correctly. The Texas Workforce Commission will, let's say you cease doing work with an independent contractor. That independent contractor then goes and files for unemployment benefits from you. That frequently will trigger an audit by the Texas Workforce Commission as to your use of independent contractors, because the TWC is looking to find that you are inappropriately using independent contractors. You're classifying workers as contractors when in fact they should be employees, because if they're employees, you owe the state unemployment tax on those folks. So they're going after those revenue streams and getting much more active on that. So be careful with your use of independent contractors.
And not to mention our friends at the IRS, because it is not uncommon if people are misclassified, especially at lower level positions, when it comes time for him or her to file their tax return and they realize they have to pay self-employment tax and they don't want to pay self-employment tax, then they go complain to the IRS, and then you have it.
And by the way, one of the best ways to help you avoid that scenario is to use a legitimate staffing agency, maybe like Imprimis, something like that. That can really help your position from a legal standpoint. So not all staffing companies are created equal. Some are better than others. That's why my firm uses Imprimis, and you should too. But seriously, they really can help you avoid legal exposure. So I encourage you to think about that. All right, let's get back to spicy.
All right, now before I take the next question, I want you all to know, I know what the Department of Labor is, okay? Okay, I know it's not the EPA. You wrote down EPA, so those are your facts now. You need to change them, okay? Next question.
Sean,
AJ, CNN, I don't know how you got here.
Thank you, Spicy. Can you explain to us the administration's stance on background checks and employment and how President Trump plans to address this issue?
Sure. Okay, first and foremost, AJ, we are completely supportive of extreme vetting, whether it's for employment or immigration, okay? This administration believes that impediments for employers to conduct background checks and to do all the unnecessary paperwork and the related penalties for that non-compliance, we don't support those, okay? Now, everyone gets all worked up about background checks, right? They're not that big a deal, okay? Everyone in this administration has fantastic backgrounds, okay? All of our credit scores, top notch, as long as you don't look at the bankruptcies, okay? Now, we believe employers should be able to handle these matters as they see fit, okay? And we don't believe that employees should have to give consent, okay, for these background checks, all right? Because, guys, we get it. If employees don't have anything to hide, there's nothing to be afraid of, right? Now, I think I've answered the question, but in the meantime, I'm going to turn this over to Ron and Paul to give some more information on this issue.
I don't think we really have any idea what the Trump administration's position is on background checks, but background checks are a serious legal issue, as Ron mentioned in his slides. Background check-based litigation under the Fair Credit Reporting Act and other state laws is on the rise. Just under the Fair Credit Reporting Act, there's about 6,000 cases a year filed, most of which are class action lawsuits, because typically if an employer is doing something wrong in their background check process, it affects multiple applicants, multiple employees, and so that's how you end up with the class action lawsuits. And you can see in the news every week multi-million-dollar settlements from home improvement stores and rideshare employers and banks. There have been settlements in the 22 million range, the 12 million range, so it can be serious money. The reason that plaintiffs' attorneys like to bring the Fair Credit Reporting Act litigation is the statute provides for attorney's fees, it provides for punitive damages, it provides for statutory penalties, so it's always easy to get a plaintiff's attorney when you can get statutory attorney's fees. Two recommendations to assist you would be use a reputable background screening company, and also competent legal counsel can help as well. Now, what are the two main areas that employers get in trouble with under the Fair Credit Reporting Act? First is the disclosure requirement, and second is the authorization requirement. The Fair Credit Reporting Act requires employers to inform applicants that they could be subject to a background check before the employer requests the background check. Where employers typically mess this up is the disclosure to the applicants has to be on a standalone document. All it can contain is the disclosure and some authorization language. Where employers mess up is a lot of employers will put the disclosure that you may be subject to a background check, they may put it on the application, they may put it on a summary of benefits, they may put it on other employment forms. Another place where employers are exposed to liabilities, you cannot have waiver of liability language in your disclosure. So that's area one. Area two is you have to obtain written consent from the subject of the background check before undertaking the background check. It has to be clear and concise language. It has to be obvious to the reader that he or she may be subject to a check and that they're authorizing such a check.
So how many folks here are doing background checks on applicants or employees? 2/3. How many of you are using a third-party vendor for that? Keep your hands up. Of those who are using a third-party vendor, wow, that's a lot of folks. How many of you are using your vendor's form? Most. There's a pretty good chance your vendor's form is wrong. I can't tell you how many background check class action lawsuits there have been over the form promulgated by the vendor. This is their business, and they're getting it wrong. So I highly encourage you to not rely on your vendor's form, with one exception. If you're using compliant background checks, one of our sponsors, with a booth right outside, I can personally vouch for their forms because I've reviewed them and my partners have reviewed them, and they're first rate. So I encourage you to talk to them. I'm serious, a lot of these background check companies are using forms that will get you sued, and you need to be particularly careful about that. And you may think, oh, they'll sue the background check company, they won't sue me, the employer. No, they're going to sue you, I promise you. So check your forms. Compounding the problem, this is one of those multi-state issues I referenced. A form that's compliant in Texas is not going to be compliant in another state. Each state has its own rules, both on the disclosure form and on the authorization form. So make sure your form is compliant in all the states you operate. To compound that problem even more, in case you want more fear walking out of here, it's not just where the states where you operate, but it's the states where folks reside when they're applying. So if you're getting applicants from Louisiana for your East Texas operations, then you have to comply not just with the law in the state of Texas, but the law of the state of Louisiana. A lot of companies make the mistake of saying, well, we operate in these 3 states and we're complying with the laws in those 3 states. And I have to ask the question, well, where are you getting applicants from? Where do they reside? Are you complying with the laws in those states?
Huge issue with online applications.
Yeah, absolutely, absolutely. So check your forms is the takeaway for you.
And just to follow up on Ron's mention of the state requirements and localities, it's not only limiting background checks, but it's also limiting specific things. There are several states and localities that limit how you can use credit inquiries. Criminal history, including the EEOC, requires you to do an individual assessment if you're going to make an adverse employment decision based on a criminal background check. And the sort of hottest, most cutting edge one that I'm still trying to get my head around is several localities are starting to ban the use of salary history in making employment decisions. You cannot ask people for their salary history. New York City is one of the most prominent of those. So just be aware, as Ron said, where you're operating, where the applications are coming from, and it's not only a state issue, it's a local issue and a federal issue.
All right, let's get back to spicy.
One more question.
Sean.
Hindu, Teen Vogue, what you got?
Spicy. I mean, Sean. Sorry about that. Gender identity and sexual orientation have been hot topics in the news lately. Can you tell us what the Trump administration's stance is on these particular issues?
Yeah, Bindu, I can. Okay, despite reports from the fake news outlets, this administration believes that gender identity and sexual orientation are, like tax returns, matters of privacy for individuals. Okay, that's what we believe, and this administration will and will always be huge supporters of the LGBT community. Okay, we are going to do and have done tremendous things in this area. Okay, now as to the status of these legal issues, I'm going to turn that over to Ron and Paul so they can provide some more insight. Okay.
Like the scroll that it says he needs already.
Yeah.
It's great. Sexual orientation, gender identity, LGBT issues are some of the hot legal issues, as you know, as HR professionals. Most recently, in the 7th Circuit Court of Appeals, they held that Title VII protects against sexual orientation discrimination. The 11th Circuit Court of Appeals has reached an opposite conclusion. There are several much older decisions from other federal courts of appeals who have held that Title VII does not protect against sexual orientation discrimination, but clearly this most recent circuit split means that it's likely going to be headed to the Supreme Court at some stage. It'll be interesting to see what the Supreme Court does. You could probably make an argument that they really could, not just being lawyers, but that they could come down on either side. The Supreme Court has previously held that discriminating against someone because they do not conform to expected sex stereotypes is a form of sex discrimination. And so it would not be too far from that logic to find that sexual orientation can be a type of discrimination, can be a type of sex discrimination. But you could also see the Supreme Court saying that if Congress wanted to protect against sexual orientation discrimination, they could add it to Title VII by adding the words. There are currently 34 states that protect against sexual orientation and gender identity discrimination. Either all employers, there's 22 that it's all employers, there's 12 more where it's public employees are protected. So clearly there is a national trend towards the protection of protection against sexual orientation discrimination. Also, the EEOC is out in front on the issue of protecting LGBT rights. They're filing enforcement actions frequently. They're filing amicus briefs in litigation involving key issues involving LGBT rights. And this type of discrimination can come up in a variety of ways, whether it's in the failure to hire, harassment, demotion, failure to promote, or firing because of orientation or gender identity issues. Denying equal access to restrooms can be a form of discrimination. And even there are cases out there now, and it's a hot issue, is the failing to use the requested pronoun can be a form of gender identity discrimination.
Yeah, and one more that is starting to percolate is whether your health insurance has to cover gender reassignment surgery and the corresponding cost of that. We'll see where this heads, but like Paul said, so many states have already passed this protection that the trend is very clear. So regardless of what happens at the federal level, you're probably still going to deal with the issue on a state level. And even outside of the legal arena, many companies, particularly large national companies, have adopted internal policies that prohibit discrimination based on sexual orientation or related status. So, frankly, 5 years from now, I think this is all going to be moot because we're going to have a common set of facts, Spicer's preferences notwithstanding. But right now, it's still in transition, no pun intended, and we'll have to continue to monitor that.
And as Ron mentioned, just a couple of statistics for you. 89% of Fortune 500 companies prohibit sexual orientation and gender identity discrimination. And so two other points to make. President Trump did keep in place the President Obama executive order that prohibited government contractors from discriminating based on sexual orientation or gender identity issues. Another issue we should probably cover quickly is the issue of restrooms and the gender identity issue. We get calls about that frequently. As you can imagine, the expectation from the government and legal authorities is that you treat gender identity just like you treat any other protected trait. You cannot ask employees to provide legal documentation or medical documentation to establish their gender identity. You can't take into account coworker concerns about who's using which bathroom. You certainly can't require the use of segregated facilities. And unisex bathrooms are certainly fine as long as they're not only for the people with the requested gender identity protection.
Yeah, and the only thing I would add is I'm sure you all do harassment training now. That's very, very common. Make sure you're covering this topic in your harassment training. If you're using an old training program, you might want to update it because this is a growing issue, and you don't want somebody second guessing your lack of training on this issue. All right, let's get back to that press conference.
Sean, okay, we have time for one more question.
Sean, over here.
NPR.
Thank you,
Yes.
Sean. The National Labor Relations Board received a lot of attention during the Obama administration for its rollback of anti-union positions that were held under prior administrations. Can you tell us what the Trump administration's position is on the NLRB and its recent rulings concerning joint employer issues and employer policies?
Sure. Heidi, I can. I will answer this question like I do all of your, frankly, weak and horrible questions, okay, with interesting facts. Okay? Let's take this. As you know, President Trump received the highest percentage of union voters since any Republican president since, who can guess? Ronald Reagan, 1980. Write it down. Click your pens, write it down, CNN. Thank you. This is a fact, okay? It's not an alternative fact, it's a fact. Check it, okay? It's like 3 plus 1 is 4, okay, guys? 2, put those together, 4 every time, okay? It's a fact. The president's performance with union voters is indicative of his love for union workers, okay? They have built fantastic, beautiful buildings all over the world, okay? Now that being said, the president does have some concern over the NLRB's recent positions, especially those seen as attacks on employers, okay? Now, while President Trump's knowledge on these issues is huge, okay? It's bigger than his inauguration crowd, bigger than his margin of victory, okay? Both of which were huge and historic. But anyway, I'm gonna let Ron and Paul give some more insight on this one, okay? Thanks.
Well, as Ron and I have mentioned over the last couple of years, certainly for non-union employers, the position that the National Labor Relations Board is out of control is an understatement. Certainly with President Trump's administration, there is hope that change will be coming. It unfortunately won't come soon enough. The current makeup of the board is only 3 of the 5. It's 1 Republican and 2 Democrats. The 2 Republican seats are open. The NLRB always has 5 seats and they rotate off 1 each after 5 years. So President Trump still needs to appoint 2 Republican members. He has not done that yet, which means if he hasn't appointed them in May, it's unlikely they're going to be in position much before the end of the year. Another complicating factor is the NLRB General Counsel, Richard Griffin, is aggressively pro-union. He's a former union lawyer. And the importance of that is the National Labor Relations Board's General Counsel is the one that decides what the policy of the NLRB is going to be and what cases they're going to go after. His term expires in November of this year. So as long as he is in place, you can expect that there will not be many cases being pushed by the National Labor Relations Board that are pro-employer. So what this all means is we're probably going to be into 2018 before we start getting some kind of relief. A couple of the big areas where we certainly need relief are the NLRB's attack on non-union employer employment policies. I mean, you've all seen the stories, their attacks on employer policies dealing with recording devices in the workplace. Their position is employees are entitled to have electronic recording devices, video recording devices in the workplace, except in very limited circumstances, because they believe employees are absolutely entitled to record their terms and conditions of employment. They're also entitled to record meetings where terms and conditions or discipline is discussed. I don't agree with that certainly, but that's the way they're looking at it at this point. Rules prohibiting employees from engaging in personal business at work have been held invalid. Employer policies where you require people to act, display professional behavior, display appropriate behavior at work have been held invalid by the National Labor Relations Board because they always think that employers have the right to criticize their supervisors and criticize their company. There is certainly a balance to be struck to protect employees' rights to complain about their terms and conditions of employment, but this board has taken it so far to the extreme that basically this current board could read any employment conduct policy that you have and find a way that it violates the National Labor Relations Act. Another issue that we are all concerned about is the board's approach to the joint employer doctrine. They came out with a very aggressive decision in 2015, and then in 2016 they further expanded it. And the National Labor Relations Board's current position is if you have a relationship with a staffing company where you ask for X number of employees that have Y qualifications, and you reserve the right to have employees replaced. If you don't like the way they're performing, you can have them send a new worker over. Under the National Labor Relations Board's view, you are a joint employer with your staff agency. So their view is basically every staff agency is a joint employer with their client employers. That's insanity, but that's the way they look at it.
Yeah, the three areas where I see the NLRB affecting employers, particularly in Texas, the most, social media policies, as Paul indicated, employers' policies are coming under attack by the National Labor Relations Board. One good example of that are social media policies where you're trying to control your brand. You're trying to prevent employees from saying negative things about your brand on social media, which you think, since you're writing their paycheck, you should be entitled to do. The National Labor Relations Board will take you to task for that. Second, employer policies that prohibit employees from discussing compensation, telling them that compensation is confidential and they can't talk about it. That's a no-no, according to the National Labor Relations Board. They're entitled to compare salaries, they're entitled to talk about their own compensation, they're entitled to talk about others' compensation. And then third, related to the social media policy, termination over a Facebook or Twitter rant by an employee. When an employee goes on Facebook and talks about how his supervisor is a fill in the blank, and that gets circled back to your desk, and the decision is we don't want someone like that working here, so you're going to fire that person. There's a very good chance that that rant on social media is protected conduct according to this National Labor Relations Board. So even if your employee calls a supervisor a bad word, and even if that bad word violates your anti-harassment policy or other conduct policy, technically that termination may be in violation of the National Labor Relations Act as interpreted by today's National Labor Relations Board. Now, there is a difference between hypothetical risk and real-world application, okay? You have a business to run. You live in the real world. I understand that. Where on that risk tolerance spectrum you fall is very much a personal decision unique to your work environment, your business owners, your superiors, everyone who runs that company. But what is the right decision for you may not be the right decision for another company with a different risk tolerance profile. So when you're evaluating what is hypothetical risk, such as the things we've outlined, I think you also need to consider where on that spectrum do you fall. What are the chances of that employee complaining about it? What are the potential ramifications? And ultimately, is the risk worth taking? Because maybe running the business the way you want to run it is more important than a very, very hypothetical risk of something coming down the road in terms of a legal claim that frankly you could make go away if it ever arises. So live in the real world and don't go putting your head in the sand just because it's so difficult out there. You have to find the right balance.
And finally, two other NLRB issues just to be aware of. One, there's a thing called Weingarten rights, which the NLRB says in a union workplace, a worker, employee, has the right to have union representation or other employee representation at a meeting that is likely to lead to discipline. The board has gone back and forth over the years as to whether or not that applies to non-union workplaces. Currently, it does not. The General Counsel asked the board late last year to hold that it does apply to non-union workplaces, and the board said no. So that's a good development. Not sure how that happened, but it happened. That's a good development. And then lastly, the one issue that's very important that will not change likely in the future, regardless of who's in charge, are the NLRB's quickie election rules. So just keep that in mind. In 2015, the board issued new election rules, which greatly expedited the time from when an election petition is filed and the election is held. The average time now is 23 days. So if you ever are faced with an election petition, you can expect the election to be 3 weeks later. It used to be about 40 days. The Fifth Circuit recently upheld the validity of those rules, and it's unlikely that the board will withdraw those, at least in the next 2 years, maybe 3 years.
So 2 final announcements. One, this chamber, the North Dallas Chamber of Commerce, sponsors or issues the Ogletree Deakins HR Professional of the Year Award each year. The nomination process kicks off with this conference, and then the winner is announced in the fall. You can get a nomination form from the Ogletree Deakins booth across the way. Interestingly, it's very easy to nominate someone. So if you want to kiss up to your boss or your best friend or even nominate yourself, that's fine. All you need to do is put that person's name on a form. There's a selection committee that will review the qualifications of all nominees and make the appropriate determinations. So there's not much you need to do in the way of nominating someone. So I encourage you, think about who is a thought leader in the HR world. You saw an example of one, our keynote speaker this morning, who was excellent. Think about who do you look up to in the HR community. We want to honor that person, so I would encourage you to think about that and nominate someone. Second, our break coming up is sponsored by Ovation Health and Life Services, and I encourage you to visit their booth and talk to them about their offerings. Thank you very much. We'll take a break.